Thank you, Your Honor. This hearing is in the matter of case number CFI 024-2021 before Justice Roger Giles. The hearing is being held by way of video conference in the DIFC courts in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Clyde & Co. Lead counsel is Mr. Anthony Jones. The defendant is not present.
Yes, well, Mr. Jones, I've read your skeleton. I've read the affidavit of Mr. Morris. That's the third affidavit and the various attachments. I have just seen, I've only skim-read the latest affidavit of the Indian service gentleman, whose name I can't remember. So that's where I...
Well, I'm very grateful for that, Your Honour. I did want to check that you had the benefit of the latest affidavit from the Indian lawyer before you. If you've read my skeleton argument, I think probably I can take it that you have a background as to why we're here today.
Yes, I can see why you want an immediate judgment application rather than a default judgment.
Indeed. It strikes me that probably there are 3 points that the court wants comfort in today. The first is why an immediate judgment rather than a default judgment, because it might seem to be a less straightforward way of proceeding in these circumstances. The second might be, given that we are making an immediate judgment application, are the conditions for that judgment satisfied? And the third would be notice of this hearing. And the notice is obviously more acute as a concern because we have had no engagement from the respondents at all.
Yes. Well, on the first point, I can understand why you want immediate judgment application, but it really doesn't matter because you have made it, and so I've got to deal with it.
Well, precisely. And so, given that it has been made, perhaps I can skip forward in my skeleton argument and take the court to the conditions for the immediate judgment application.
Can I interrupt? I think before we get to that,
of course,
your submissions deal with it, and in one respect, rather oddly, can we just have a discussion about jurisdiction over these two defendants?
Of course.
Where is the jurisdiction?
So we established jurisdiction over these defendants because they have been they have been served outside the jurisdiction.
That doesn't give jurisdiction, though, not under the DIFC rules. Service is not enough.
So service, I appreciate that, Your Honour, but it is the starting point. That service is the starting point for jurisdiction, and service has been affected, we say, under DIFC law because it's service in a fashion which is allowed in the jurisdiction in which they are resident, which is India.
Okay, well, we'll come to service. I did want to just go through that with you also, but the starting point is jurisdiction.
Indeed, and the basis on which we rely is that these are claims, the claims against the second and third defendants are claims which can be brought at the same time as the claim against the first defendant. And so it's convenient for them to be brought together. And if we go to the basis of I think we've got and the independent ground of jurisdiction over these defendants is set out in Article 5, and it's Article 5A2. We've got it at page 491 of the case lines bundle.
Right. Well,
I'm sure the court's familiar with it.
Article 5A is graven on my heart. But
Indeed.
where do you get the agreement to in effect, in other language, the submission jurisdiction? And in this case, I'm asking that because your written submissions do not seem entirely correct on that. You seem in your written submissions to say, pardon me, to rely on clause 11 of the purchase factoring agreement. I'm looking at paragraphs 24 and 25 of your written submission, and while there may be other grounds, of course, it just does not seem to me at the moment that that's correct.
So if we go to, yes, so paragraph 24 and 25 of my skeleton argument sets out that the second and third, the claim against second and third defendants is a dispute arising out of the purchase factoring agreement.
Yes, but where do you, the clause of the purchase factoring agreement, I'm not, that is 11.1, which you refer to in 24. That, however, is an agreement only between the company and the bank. These two persons are not individually parties to that agreement.
And then if we go, you're right, I appreciate that. They're not parties to the purchase factoring agreement themselves. If we then go to the guarantees to which they are parties, each guarantee provides in clauses 11 of those guarantees clauses
13
of those guarantees, which I just put. So that provides non-exclusive jurisdiction of the UAE courts.
Yeah, well, let me just understand what you are saying. You see, your written submissions seemed to rely on clause 11 of purchase factoring agreement.
Yes.
In paragraphs 24 and 25. I've suggested that that's wrong. It's not enough because they weren't parties to it. Then you do refer in paragraph 26, without actually referencing it to the clause 13 of the guarantee agreement, to the courts coming within courts of the UAE or courts of Dubai, which I assumed was intended as an alternative to take up reliance on clause 13 of the guarantees. Now, am I right?
Yes, Your Honour. So the structure that I'm seeking to set out in my skeleton argument is that if this is interpreted as a dispute arising out of the purchasing factoring agreement, then it is right that it should be before this court, because it is substantively a dispute that arises out of an agreement which grants exclusive jurisdiction to this court. but in respect of jurisdiction over the individuals.
Well,
Sorry.
that matters not. It's not the dispute. We need to fit within Article 5A. You have referred to Article 5A1 or 5A2, the opt-in.
Yes.
Now, we are looking for an opt-in.
Indeed, Your Honour.
Do you still say that Clause 11 of the Purchasing Factor Agreement is an opt-in that captures these two people or not?
Not in terms, Your Honour.
Well,
the thing which captures them, Your Honour, the thing which captures them is their opt-in under the guarantees, because the guarantees refer to the courts of the UAE.
Okay, well, if that's good enough, that's good enough. But I just want to know, because it should be plain, it does not seem to be correct, whether you do say that Clause 11 covers it. If they've opted in, then we look at the terms of their opt-in.
Indeed, Your Honour, and this lack of clarity is my fault. What I was seeking to do was to establish that the subject matter of the dispute comes within this court's jurisdiction, and then to establish that the individual defendants are proper defendants under the jurisdiction of this court due to their own opt-in as well. I'm sorry.
What has the subject matter of the dispute got to do with jurisdiction?
Well, you're right, Your Honour.
Does that help you at all?
Your Honour, in terms, no, it doesn't. But I wanted to make sure that the court was comfortable that we are not coming before this court with a dispute which is properly, or with a dispute which has connection to another jurisdiction. Because, of course, if this court were to say that someone has, well, if this court were to be unsure about jurisdiction over the defendants, the question of the proper forum might be one that this court was going to advert to. I'm sorry for that red herring.
This was an anticipatory strike against a forum non-convenience argument.
In a way, Your Honour, just trying to establish on all grounds that this is the court to be discussing this issue. I'm sorry for any lack of clarity, completely on my part.
Right. Well, now we'll just come back to Clause 13 opt-in in a second. But is the bank a DIFC establishment?
There is a DIFC establishment branch of the bank, yes.
Well, no. Is the bank a DIFC establishment within the terms of Article 5A?
I am instructed that the bank is a DIFC establishment. Its head is Maltese, and it has a DIFC establishment, so it is a DIFC entity.
No, that is not the test. The fact that it happens to have an office in the DIFC and in that sense has an establishment isn't the test. Have a look at Article 5A and see what it says about a DIFC establishment. I would have thought that if the bank was carrying on the business in the DIFC, it should be, but there is no evidence that tells me that it is. If it is, then you've got jurisdiction hands down for that reason.
Well, I will just check. I think. I'm just with your permission, I hope, Your Honor, I'm just sending an email to double check that point to my instructing solicitors.
Yes.
I understand it to be the position. I'll just get confirmation from them.
But while we are waiting, could you just remind me, because I've got case lines on the iPad and I'll lose it if I look up the definition again myself. What is the definition of a DIFC establishment?
So I think it's in Article 19(1)(a).
Yeah. No.
So under Law 10 of 2004, it's Article 19(1)(a), which reads.
Why are you looking at that? Why aren't you looking at the judicial authority law?
Sorry.
That's where Article 5A is. And it's the dominant one because Law 10 says or refers back to it. I'll just leave the screen for a moment to get a book, which I think should have it in front of me.
Yes, Your Honour. So in the case lines bundle at page 489 is the definition under Article 12, under Law 12, 2004. So the Judicial Authority Act. And its definition of DIFC establishment is any entity or enterprise established, licensed, registered, or authorised to carry on business or conduct any activity within the DIFC pursuant to DIFC laws, including licensed DIFC establishments.
Right. So now, is the bank licensed to carry on business, etc., in accordance with that definition?
Yes, it is. My instructor have just sent me the extract of the public register, setting out its license to carry on business activities, including arranging credit and advising on credit, with its registered offices being in the Emirates Financial Towers, DIFC, Dubai.
Right. Well, now why isn't that good enough under Article 5A, 1A?
Well, it would be, Your Honour.
I think one needs to track it through a bit, but I think actually the one I'm looking at is not up to date. Go back and read to me again, please, the definition in the JAL.
So, and just for your note, it's page 489 of this bundle. That is here.
Yeah, I can just hang on while I find that. Yes, thank you. I do have that. No, I should have gone to it earlier.
No, I should have taken you to it earlier. I apologise.
All right. Well, if the bank is an entity licensed, registered, or authorised by the DFSA to provide financial services or do any other activities, then it's a licensed DIFC establishment. It's a DIFC establishment under Article 5A1A. The claim or action is one to which it, as a licensed DIFC establishment, is a party. It's the claimant.
That's true, Your Honour, and doubtless that would have been a much more straightforward way of doing this.
This is common. This is where an awful lot of our cases come from. The connection with Dubai is solely often because a foreign bank happens to have a branch in the DIFC which is licensed to carry on business in the DIFC. That's good enough.
Well, Your Honour, frankly, if that's good enough for the court, then that's good enough for us. You will see the way in which it is put. It is put in a way, or it has been put up to now, in a way that relies on trying to make it crystal clear that the respondents have submitted. But in fact, the way in which the jurisdiction of the court is invoked in the claim form, which is at page 3 of the bundle, is precisely the way that we've just discussed, which is the fact of the claimant being a DIFC establishment.
Okay. Now, I think I may need some evidence, and I was going to say, if Mr. Morris is available, and I think I see his initials on screen, I think it might be useful if he were sworn and confirmed the contents of his witness statement, so that we do have a statement on oath, which may or may not help you at a later stage. And he can also give me some evidence which gives me the evidence that the bank is a DIFC establishment. Are you happy to do that?
Yes, Your Honour. I'm happy to do that.
Yes,
Okay.
well, we'll follow the procedure. Mr. Jones will first of all that echo. Oh, this is a test statement of some kind. Is that better? Can you both hear me? All right. Well, Mr. Jones will call Mr. Morris to give evidence. Charlotte, if you're there, be prepared to swear Mr. Morris, please. Mr. Jones will then do those two things. One, get you to confirm on oath the contents of your third witness statement, and secondly, get you to give some evidence to support the proposition that the bank is a licensed DIFC establishment. Go ahead, Mr. Jones. You call your witness.
I'm grateful, Your Honour. So on behalf of the claimant, we call Mr. Michael Morris.
Thank you. Charlotte, please swear, Mr.
Mr. Morris, would you like to affirm or swear?
I will. Well, I don't have a Bible, so I'll affirm, please.
Okay, so please repeat after me. I affirm to tell the truth, nothing but the truth,
I affirm to tell the truth, nothing but the truth,
and the whole truth.
and the whole truth.
I apologize. Can I just confirm? I was not prepared for the affirmation.
Okay.
Take your time, Charlotte. Just get organised and we'll start again.
Okay, thank you, Your Honor. Thank you for your patience, Your Honor. I have the statement in front of me. I apologize for the inconvenience. Mr. Morris, please repeat after me. I affirm that I will tell the truth, the whole truth, and nothing but the truth.
I affirm I will tell the truth, the whole truth, and nothing but the truth.
Thank you.
Mr. Morris, I take it you're in Dubai at the moment, are you? At
Yes,
your
I-
office? Thank you. Yes, thank you, Mr. Jones.
Grateful. Mr. Morris, do you have the bundle for the hearing in front of you?
I do not have it, but I do have my third witness statement.
Well, I'm grateful. Can I take you to the final page of the third witness statement?
Yes.
Your Honour, for the purposes of the bundle, it's at page 224.
Thank you.
Mr. Morris, on the final page of that witness statement, there's a signature. And whose signature is that?
My signature.
And when you signed this document, was it true at the time you signed it?
Yes, it was.
And to the best of your knowledge, is it still true?
Yes, it is.
On that basis, Your Honour, the claimant would rely on this as the claimant's evidence in support of this application, with one additional area of questioning, which I'd just like to explore with Mr. Morris.
Yes, go ahead.
Mr. Morris, can I take you to, or can I read out these words from the judicial authority law of the DIFC? The DIFC judicial authority law refers to DIFC establishments, and that definition is any entity or enterprise established, licensed, registered, or authorized to carry on business or conduct any activity within the DIFC pursuant to DIFC laws. Does that definition fit Fimbank, the claimant in this matter, or not?
Yeah, yes, it does.
And why do you say that?
Because, to the best of my knowledge, a license to they are registered in Malta. They have a branch in the DIFC, and they are licensed to do business in the DIFC.
I'm grateful. Your Honour, that's the evidence on which the claimant relies.
Yes, thank you. Yes. Thank you, Mr. Morris.
Thank you.
All right. Well, now that deals with the question of jurisdiction over the claim itself. Is it convenient to, before we get to the merits of it, to deal with the question of notice of this hearing?
That's probably sensible. That's probably sensible, Your Honour. So you will have seen that there has been a lack of engagement throughout on the part of the defendants. What is required in terms of notice is set out in Rule 24.6 of the rules of the DIFC courts. And what that provides is that where an immediate judgment hearing is fixed, the respondent must be given at least 14 days notice of the date fixed for the hearing and the issues which it is proposed that the court will decide at the hearing. What the claimant says is, first, it's noteworthy that the wording of 24.6 refers to notice rather than referring to formal service in any particular form. And so what we say as a starting point is that notice must just be given its natural meaning, namely that notice has in fact been provided to the defendants. And what the claimant says is that the second and third defendants, the respondents to this application, have been given such notice. And the fashion in which that was done was that it was sent to their recently used email addresses on the 27th of January, which was 24 days prior to this hearing. The reason why it was sent to those email addresses and the reason why the claimant says that this court can take that as being giving notice is that those email addresses have been recently used by the second and third defendants, and that both email addresses gave delivery receipts, and the third defendant's address indeed gave a read receipt when the proceedings were sent to them. So both addresses were used to send the proceedings as well as service of the proceedings. And both addresses gave delivery receipts to the proceedings being sent to them in April 2021.
Where, please, do I find the evidence of that they are recently used email addresses? In other words, that they were used for other purposes at some recent time.
Certainly. So the in tab 17 of the bundle, tab 17.
Give me a page would help, please.
Sorry, so page 406 to 411. Sorry, to 406 to 415 is tab 17, and that's a string of email exchanges between Mr. Rajiv Bhatia, the second defendant. If you go down to page 412, that's the first of the emails, and as is the case, it's sort of in reverse chronological order, the paging. So page 412, we see in December 2019, the email being used by Rajiv Bhatia to send communications to Fimbank.
Yes, I see that. Yep.
And there's a string of such communications which bring us up to page 407, right. Which is in January of 2020. That's the most recent evidence of the email address being used.
That's the
second defendant.
What about the third defendant?
So the third defendant's email address, stbbhatiatraders.com, is the email address which was the email address of the third defendant during his business. It hasn't been recently, in the sense of in the past year or so, used for correspondence with the claimant, because as a matter of fact, the second defendant was the party that did most of the correspondence. What we say in showing that it's an email address which is live and recently accessed is that read receipts from the third defendant's email address have been received in respect of the proceedings when they were served.
Well, so now take it step by step. Is there some evidence of his email address at an earlier time, even if not in the last year or so? In other words, when the company was doing business?
Not in this bundle.
Okay. Mm-hmm. All right.
And so the email addresses, but the email addresses are the email addresses that the claimant has on file for these business parties, and that's why they were the email addresses to which the documents were sent when the documents were being served. They were served physically under Indian law as well, and they were sent as email attachments. And I can take you to what I hope is the read receipt. Oh, sorry, I can take you to the certificate of service, which was granted by this court on the basis of the alternative service that was granted for the claim. And the alternative service that was granted for the claim by this court, it's page 160 of the bundle, was to those email addresses.
No, that's fine. Well, then, if I remember rightly, I can remember seeing evidence of one read receipt for notice of the date of this application, but you seem to have been talking about two of them. I'm not too sure whether that's because I'm wrong or because you're wrong.
Well, Your Honour, it is because I actually think it's because we're referring to slightly different things. The read receipt of this application, there has been one, and that is the read receipt from the email of the third defendant, so STB Bhatia Traders, and that I can take you to that, which is page 424 of the bundle.
I remember, that must be the one I remember, right?
Indeed. So that is a read receipt of this application being sent to the third respondent, and that email having been opened and read.
No, let me just make sure that I'm on the same wavelength. Of they were sent the application, and then separately and later they were sent notice of the date. Which one are we talking about here?
So they were sent notice of the date as well. That was on the 27th of January 2022. So I set it out on page 21 of my skeleton argument, the attempts to give notice, or the attempts to make them aware of what was going on. So the email of the 27th of January 2022 from my instructing solicitors to those two email addresses, and a read receipt of that one, a read receipt of giving notice of this hearing was also obtained from the email address of the third defendant.
Right, now, what's the page for that, please? Just
that page.
Sure I've got it.
Of course, that's page 419 of the bundle.
Okay. All right.
And coupled with that attempt to make them aware of the hearings by way of sending the emails, that's been backed up by the attempt to physically deliver a letter setting out notice of the hearing, and also letting them know the details for joining, which was attempted to be served by the means which had previously been successful in giving physical service. So attempted to be served by way of courier in India, but it was rejected. And the most recent affidavit sets out an attempt to deliver it physically to the door and give hand notice, and that was rejected by the persons at the address.
That from that recent affidavit, the most recent attempts to deliver packets, A, personally at the door, B, by courier, and C, by registered post, all were not successful.
Exactly.
Now, where do I have some evidence that the address at which there were, to which, for example, there was earlier courier delivery, is the address of these two gentlemen?
Think Now, the addresses that the claimant has are their last known contact addresses in India. That's recorded in the third witness statement of Mr. Morris, that they're the last known contact addresses.
Simply as that description by Mr. Morris.
Yes.
In other words, I don't have anything more definite like this is from their files or from the bank's files or anything like that.
Not in terms, Your Honour, no.
Okay. All right.
So what we can say is that, and this is simply a matter of instruction. I am instructed that the most recent attempt to physically deliver the documents to the addresses in Mumbai was met not just by refusal from the persons who happened to be there, but by a statement that the defendants had gone back to the UAE. Whether or not that's true, that they've gone back to the UAE, it in my submission underscores the fact that this is the address of the business people who are frequently in the UAE or have been in the UAE. And so it gels with this being the address of the Bhatias.
Yeah. All right. No, well, I think I am satisfied about service of the application and notice of today's date. So we can move to the substance.
Indeed, Your Honour. And so
the substance is fairly ordinary in a sense, isn't it?
Well, that's my hope, Your Honour, that now we might be perhaps on less choppy waters, though of course the chop is entirely of my own making, Your Honour. The substance of the application is set out in my skeleton argument, but I'm sure, Your Honour, you see it very clearly. The grounds for immediate judgment, as set out in Part 24 of the rules of the DIFC court, are no great surprise. They are that if the court considers that the defendant has no real prospect of successfully defending the claim, and there is no other compelling reason why the case should be disposed of at trial, then the court has jurisdiction to grant immediate judgment. Now, if the court is satisfied, as I understand it now is, with jurisdiction over the claim, then that would be something which wouldn't provide a grounds for a successful defence. And so the only possible ground of successful defence would be, is there a substantive defence to the requirement to repay under the guarantee agreements? Now, the guarantee agreements in my submission are a very straightforward form. They provide, as is entirely standard, a primary obligation on the part of the guarantors to pay the indebtedness that the guaranteed party owes to the claimant. That's backed up by an indemnity obligation that the second and third defendants as guarantors should indemnify the claimant for any damages and costs which arise from the guaranteed party, namely the first defendant, failing to pay. So there are two operative obligations, both a primary obligation to pay upon demand and a second obligation to indemnify if the first defendant does not pay.
Yeah.
So those are set out in clause 2 of each of the guarantee agreements, which are both in substantively identical form.
Yeah.
And what has happened in this case is that the claimant has, as a matter of fact, made multiple demands for repayment. It served pro forma demands for payment from November 2019 onwards in respect of the outstanding balances. And then, in my submission, crucially, in December, in that string of correspondence to which I took you earlier, between December 2019 and January 2020, the claimant requests again repayment of the indebtedness. And importantly, the second defendant acknowledges the debt and repeatedly asks for some time to provide the money. That's, in my submission, the clear evidence that the request for the payment has been made. And indeed, not that it particularly matters, but there's also the acknowledgement on the part of the second defendant that he is bound and that the repayment has to occur. Then, of course, we're now in a situation where all of that is bolstered by the fact that the claim form and the particulars of claim have been served, where payment is demanded from the first defendant. That first defendant has defaulted on payment and default judgment has been granted against them. So that's a separate basis which enlivens the indemnity obligation.
This is a question arising with apologies out of my not having it in mind as I read the papers. The guarantees require a demand made by the bank on the guarantors. In other words, a demand to the company to pay is different from a demand to the guarantors to pay. Can you help me on where the evidence is the demand on the guarantors, please?
Yes, so, Your Honour, it is true to say that there is not in terms a written document which says this is sent to you as guarantors, seeking your payment as guarantors. What there is correspondence sent to the guarantors, which sets out the indebtedness of the company and requires repayment. We say that in circumstances where the guarantee requires a demand in writing, but the guarantee's definition of what a demand in writing is very broad. So I'll just take you to page 372 of the bundle, if I can, to make good that submission.
I have a separate copy of the guarantee. What clause is that?
Of course, so it's in the interpretation clause of the guarantee. It's the second definition in interpretation. So on the over the page, just before clause 2, it says writing or in writing. Yes, shall mean any method of visual representation and shall include facsimile transmissions, telexes, and other electronic methods.
Does that solve the possible problem? I'm not saying there is one, but it's something that needs to be thought about. If there's a letter to the company saying, company, please pay, even if it's addressed to one of the personal defendants as an officer of the company, are they entitled to say to themselves, well, thank goodness they're only demanding the company, they haven't got around to demanding it from me yet?
Well, I appreciate, Your Honour, that is a potential problem, because it does not in terms say this is a demand both from the company and against you as guarantor. It is true that that's not what it says in express terms. What I say is that first, in circumstances where the guarantors are the people receiving the correspondence which is directed to the company, and in circumstances where their guarantee is coterminous with the company's obligation to pay, and is independent as well, such that any demand against the company can also be a demand against them under the guarantee, because it doesn't require the company first to default before their guarantee obligations are enlightened. In those circumstances, I say that the proper interpretation of requests made to the company for payment is that they are requests both against the purchase factoring agreement and against the guarantees.
Is there, just hang on a second. Is there anything in the response or responses to those demands on the company that indicates that the individuals also regarded it as enlivening their guarantor obligations?
Well, it's fair to say that the responses from the individuals don't use any particular formal terminology. So it's not as though they refer to the guarantee in terms. What the responses say, so page 410 is one of the responses from Mr. Rajiv Bhatia. Asking for indulgence. He provides the company information and he says, I'm working on getting additional equity into the company. I shall keep you updated on further developments. That response refers to the company. And then page 408, Mr. Rajiv Bhatia replies again to the demand. So this is the 22nd of December 2019, in the words, we will settle 25% by the 31st of December and another 25% by the 7th of January and the balance of 50% by the 15th of January. There's no clarity either way.
It goes on to talk about the business situation. I have to say that it looks to me like we means the company.
Well, I don't resist that reading, right? It's certainly not explicit one way or the other, but it says what it says. What I say is first, as I've said, the circumstances of the guarantee and the purchase factoring agreement being in lockstep with each other, such that indebtedness under one is indebtedness under the other, or rather indebtedness under the purchase factoring agreement is indebtedness under the guarantee, and simply needs to be paid on demand, mean that any payment which is, or any request made factually to the guarantors is also a request for repayment from them as guarantor, as well as a request for repayment from the first defendant. But I bolster that by saying that even if that issue is not determinative, or even if that is not something on which the court is happy to give immediate judgment, the important thing is that the guarantee obligation also has this separate obligation of indemnity in cases of the default of the primary obliger.
But that's also indemnity on demand.
Yes, but indemnity on demand, with the demand being the particulars of claim and this claim being brought. So
well, that leads to two things. I see a potential problem here. There are two things that might need further investigation. One, there may be some authority knocking around somewhere in the books on guarantees to showing when the demand on the principal debtor can be regarded as a demand on the guarantors in a situation like this, because it's common that the company officers are the guarantors. And the second is whether or not the commencement of the proceedings can itself be regarded as a demand, or whether on the traditional old strictness, your cause of action had to accrue before you began the proceedings, and it therefore could not accrue by the beginning of the proceedings, if you follow me. It's not a subject which I can have any particular recollection of dealing with. So it does problem me a little, and I think I should give you the opportunity after we finish this hearing to look into both those aspects and see if you can help to overcome some questions in my mind.
I appreciate that opportunity, Your Honour. It may be that we can clarify things in written submissions afterwards.
Yes, I mean, I must say I really don't understand why the bank didn't read this and send separate demands anyway. That's what people have done.
Your Honour, in the overused phrase, we are where we are.
Exactly, yes. It is what it is, as someone said once.
Indeed, indeed. Quod scripsi, scripsi.
Yeah. All right. That seems to me to be about the only potential problem in otherwise on the merits of the case. But two things. One, as a matter of formality, can you tell me where the actual application notice is in the bundle, please?
It might be that it's not there.
That's possibly why I was asking the question.
Yeah.
It'll
Yes,
be on the court file and I can find it. But
I think, unfortunately, I'm just wondering whether it might be in an exhibit to an affidavit of service, but I think probably not. So.
Yeah, no. I don't know if Mr. Morris can perhaps search for it while we.
I'm sure it can be obtained.
My next question then is quantum. We've got the principal amount. Interest has been calculated to sometime, I think, the end of November last year. What are you proposing to do about quantum?
Well, if you are granting me, Your Honour, the opportunity to make some tying up written submissions, it may be that that's the place for sterile calculation of interest as well.
I think that's probably right, because it's not necessarily just a case of a daily rate, because the LIBOR rate may change.
Precisely. And I recall at the time that the immediate judgment application was being made, there were some complex calculations about interest, and it probably is fair to the court for them to be set out in a bit of detail so that the court has comfort that the relevant rates and the proper rigour has been applied to them.
Yes, that is a good idea, because the 3 or 4 lines in the materials presently are there's a deal of taking on trust. So I think I should have an affidavit, not a witness statement, but affidavit. Let's go for evidence on oath, which brings the calculation of interest up to the latest date that you can, and that'll be the date, assuming that there is judgment, for which judgment will be given. You might miss out on a little bit of interest, but it may not matter.
That's very sensible, Your Honour. The other matter, of course, would be an application for the claimant's costs. I have to inform that I think, unfortunately, there may have been a slight IT snarl. I'm instructed that statements of costs were served on Friday, but and acknowledgement of receipt was received from the court on Friday, but that due to some unexplained difficulty, they needed to be refiled because the statements which had been received by the court were blank. So they have been refiled this morning, I understand, in a format that has been accepted.
Yeah, one has been sent through to me. I have not looked at it yet, but so it will need to be taken care of course, in due course. Again, assuming there is judgment. The only complication that I see at the moment, Mr. Jones, is this question of demand.
I entirely understand, Your Honour. Your Honour, I should say that my very industrious instructive solicitors are sending me copies of the application notice by email. I wonder if perhaps I can send it on to you and your clerk, just to give you comfort.
Well, perhaps Charlotte, send it to the court, and Charlotte, if you would be good enough to just forward it on to me so I don't have to search for it in the file.
Brilliant.
Yes, Your Honour, will do.
All right.
So, all right. Well, no. So then the outstanding matters are some further submissions from you on those two aspects of demand to try and overcome any problem there may be. Make no mistake, I am slightly troubled by it, Mr. Jones, because if a guarantee says you've got to pay on demand, you're entitled to say, but you haven't demanded yet.
I can see the argument, Your Honour. It's entirely proper that we deal with it fair and square, and in a way that's overwhelming, such that the court can be satisfied that immediate judgment should be granted.
Yeah, it is immediate judgment. It's so, and then an updated calculation. So those two things. There's no fixed time as far as I'm concerned. It's the claimant who wants to make the timing. So, but we should have a time, I think. When do you want to make the time for having those materials in?
Well, I don't have instructions specifically on this point, Your Honour, not in fact having anticipated it. But for my part, it could be very quickly. I would imagine at the end of the week could be achieved from my side of things. It may, and I only say may, take Mr. Morris some more time because he may have other commitments that make it difficult for him to swear an affidavit in the coming days. I see he's come on screen. Perhaps we can just ask him to comment.
Yes, Mr. Morris, so far as getting the updated calculation goes.
Yeah, we'd need to get those from the bank. So as soon as the hearing finishes, I will inform the bank that we need the updated calculation. We can prepare the affidavit by the end of this week. But shall we say just to be on the safe side, this time next week? So we've got one more week.
Let's say for both those things, the further submissions and the affidavit of calculation within 10 days.
Very much.
I'm grateful.
All right. Well, there's nothing else from my end, Mr. Jones. Is there anything else you want to raise? Otherwise, I'll simply reserve my decision subject to further submissions and the further materials on calculation.
I'm grateful, Your Honour. The only thing I wanted to check was, frankly, the format of that, whether as a matter of form you're adjourning this hearing part heard and we'll come back again, or whether the hearing is over and you'll reserve judgment subject to further written submissions.
The latter, but if I feel the need for further communication with you, I will say so, and we will then reconvene the hearing.
Of course, of course. I'm grateful, Your Honour.
All right, nothing else then. Thank you very much. Well, the court will adjourn, possibly not never to reconvene.
Indeed.
Thank you.